Reynolds v. State. Annotate this case Reynolds v. State 2022 OKCR 14 case number F-2019-696 decided August 4, 2022 Frank Reynolds, appellant v. The State of Oklahoma, appellee. OKINION. Roland, presiding judge. Pilcrosign 1 Appellant Frank Reynolds appeals his judgment and sentence from the District Court of Oklahoma County, case no. CF-2018-1845, for murder in the first degree, in violation of 21-0.S.Up.2012, paragraph 701.7. The Honorable Natalie Mai, District Judge, presided over Reynolds' jury trial and sentenced him, in accordance with the jury's verdict, to life imprisonment without the possibility of parole. Reynolds raises 6 issues on appeal. 1. Whether the compelled disclosure of his home surveillance system password violated his Fifth Amendment right against self-incrimination. 2. Whether the district court erred by denying his motion to dismiss based upon Oklahoma's Stand Your Ground law. 3. Whether the district court abused its discretion in denying his request for an instruction on the Stand Your Ground defense. 4. Whether he was denied the right to present a defense by the denial of a jury instruction on the Stand Your Ground defense. 5. Whether the evidence was sufficient for conviction. And 6. Whether an accumulation of error deprived him of a fair trial. Pilcrosign 2 We find relief is not required and affirm the judgment and sentence of the district court. Facts. Pilcrosign 3 Reynolds fatally shot his daughter's boyfriend, Joseph Michael Groh, in Reynolds' Del City home on April 21, 2018. 1 Reynolds claimed the shooting was justified under a Stand Your Ground self-defense theory. The incident was captured on Reynolds' digital video recorder (DVR) home surveillance system. Police discovered the existence of the surveillance system early on in the investigation and believed the system was recording during the shooting. Detectives asked Reynolds for the password, but he refused to disclose it and asked to speak with his attorney. Later, an investigator obtained a warrant to seize and search the device. The investigation's commander presented the search warrant to Reynolds and told him the warrant required him to give police the password. Based upon the commander's representations, Reynolds disclosed the password. Police obtained the video footage of the shooting and it was played for the jury during the prosecution's case over Reynolds' objection. 2 Although it appeared the two had been bickering before the fatal shooting and witnesses testified that Reynolds had asked Groh to leave several times throughout the day, the footage showed that Groh did not make any physically threatening movements toward Reynolds immediately before the shooting. 1. The compelled disclosure of the password. Pilcrosign 4 We must decide, as a matter of first impression, whether Reynolds' compelled disclosure of the password to his password-protected DVR home surveillance system violated the self-incrimination clause of the Fifth Amendment to the United States Constitution or the corresponding provision against self-incrimination in the Oklahoma Constitution. 3 Reynolds moved to suppress his security system's video footage of the day's events and the fatal shooting incident based upon various violations of his constitutional rights, including his Fifth Amendment privilege against self-incrimination. The district court denied Reynolds' suppression motion relying upon the foregone conclusion doctrine. It concluded Reynolds' disclosure of the DVR password was most likely testimonial in nature within the context of the Fifth Amendment, but that the foregone conclusion doctrine applied because the prosecution had sufficiently shown the requirements of the doctrine, namely, 1. That the police knew about the DVR system's existence prior to the password's disclosure, 2. That Reynolds had sole possession and control of the system, and 3. That the evidence was authentic. For reasons discussed below, we hold that the compelled disclosure in this case did not violate Reynolds' constitutional rights based upon the Fifth Amendment's foregone conclusion doctrine. 4 Accordingly, we find that the district court did not abuse its discretion in denying Reynolds' motion to suppress and admitting the video at trial. See Bramlett v. State, 2018 OKCR 19. Pill cosine 10, 422, p.3d 788, 793, reviewing rulings on motions to suppress for an abuse of discretion. Many blasphemous aliyah names to their family tree and having ownership changes, and many time it and Alice Reese aka Louis Reese the transgender grandma killer aka Sheriff Carmen Marcino files false lawsuit on some of the family members as they've done all this in my family tree, adding it's blasphemous Michael Monty and doing the false lawsuit on me Victor Etheridge the third, and right before they killed my grandfather and rubbed it in my face for days up to weeks later, it told me in the Gorge I could not stop him laughing and trying it ever so often, its murder attempts with its need for scoffing ever so often. The false prophet aka all fraud Kent Christmas aka leader of Satanic Temple, as can be seen on YouTube aka ECT, has a need to put its little index finger and point it in real prophets' faces and tell us how it is, and then remind us that it has told us already how it is and how God obviously doesn't care to listen to our prayers, and reminds us how it would run if it was us, and how we should kill ourselves because it says no one cares and that we have no hope.
Oh shit, here we go again. Oh shit, here we go again.